a silent earthquake in the Constitution. At the center of this case is the story of Barnes versus Felix fast-moving confrontation that changed everything. It began when Officer Robert Felix Jr. pulled over a man named Ashton Barnes for suspected traffic violations, a routine stop until it wasn't. The officer asked Barnes to exit the vehicle. Barnes opened the door and appeared to comply, but in a sudden, unexpected move, he tried to drive off. Reacting on instinct, Officer Felix jumped onto the door ledge of the moving car. Within 2 seconds, he pulled his weapon and fired 2 shots into the vehicle. Barnes was hit, fatally wounded. The entire incident, from the car's movement to the fatal shots, unfolded in just 5 seconds. Afterward, Barnes's mother filed a lawsuit against Officer Felix, arguing that her son's Fourth Amendment rights had been violated through the use of excessive force. And so, the legal question became unavoidable. Was Officer Felix justified in using deadly force in that instant of perceived danger? And even more critically, what legal standards should courts rely on when judging police use of force? The moment of threat. Standard. For years, lower courts, especially the Fifth Circuit, followed a narrow test known as the moment of threat standard. Under this rule, judges only looked at the exact moment an officer pulled the trigger, not what happened before and not what came after. If the officer claimed they felt threatened in that split second, the use of deadly force was justified. No further questions asked. That's exactly how the courts ruled in this case. Both the District Court and the Fifth Circuit sided with Officer Felix. They ruled that the 2 seconds he was clinging to the car while it moved gave him enough reason to fire his weapon. But here's the problem with that logic. Context didn't matter. What caused the officer to step onto the car in the first place? Could the encounter have been safely de-escalated earlier? Were Barnes's actions actually dangerous or misunderstood in the moment? All of those questions were off-limits under the moment of threat framework. And that's precisely what the Supreme Court found so deeply troubling. In a powerful 9-0 ruling authored by the Supreme Court's rejection of narrow analysis Justice Elena Kagan, the Supreme Court struck down the moment of threat doctrine completely. The justices made it clear courts can no longer judge police use of force based on a single frozen moment. Instead, they must look at the totality of circumstances. That means everything counts. The full timeline of the encounter, the officer's decisions leading up to the use of force, and whether that force was objectively reasonable. Not in hindsight, but from the point of view of a reasonable officer at the scene. The ruling emphasized that the totality analysis isn't confined to a few seconds. There's no time limit. Earlier details like verbal commands, de-escalation attempts, or unclear behavior may explain why something appeared threatening or why it didn't. In short, context matters. And with that, the court set a new nationwide standard, one that rewrites how excessive force cases are judged and reshapes every future encounter between law enforcement and citizens across the country. Now, why gun owners should care? You might be wondering, what does any of this have to do with the Second Amendment? The answer, everything. Across the country, more and more law-abiding gun owners are finding themselves in tense, high-stakes moments with law enforcement. Maybe it's a routine traffic stop where you legally disclose that you're carrying. Maybe it's a red flag visit at your door. Or maybe it's mistaken identity because you're open carrying in a public space. In those moments, the situation can escalate fast. And under the old rules, courts only looked at the final second, the moment of force, and often ignored everything that came before. This ruling flips that. It gives courts the power to evaluate the entire encounter, including whether an officer misinterpreted your legal actions as threatening. That matters a lot because for gun owners, that could be the difference between being falsely blamed for a tragic outcome or having a judge recognize that your rights were violated. The Fourth Amendment, your protection from unreasonable force, and the Second Amendment, your right to carry, are now more connected than ever before, and this decision just brought them closer. The totality of circumstances. A new legal framework. The Supreme Court didn't just throw out an outdated doctrine, it replaced it with something far more powerful. By shifting the focus to the totality of circumstances, the court created a clearer, fairer, and more balanced way to evaluate police use of force. No more zooming in on a single second. No more ignoring everything that led up to the moment a trigger was pulled. Now, both sides of the story matter. What the officer believed and what actually happened. Here's what courts are now required to do. Examine the full timeline, not just the final heartbeat before shots are fired. Reject split-second justification if that split second was shaped by earlier decisions the officer made. Consider all relevant signals, prior interactions, verbal warnings, behavior patterns, escalation or de-escalation attempts. All of this becomes legally meaningful evidence, and that changes everything. Now, self-defense cases, wrongful shooting claims, and encounters involving lawful gun owners will be judged with full context, not a cropped snapshot. It's a standard rooted in fairness, one that brings real constitutional depth back to how the Fourth Amendment is applied in modern policing. And for the first time in years, the courts must consider the whole story. This ruling wasn't repercussions for state and federal courts, a gentle correction. It was a nationwide course reset. The Supreme Court's decision wasn't just aimed at the Fifth Circuit. It was a direct challenge to decades of how multiple federal circuits have handled excessive force cases across the country. Some courts had embraced versions of the moment of threat rule. Others applied broader standards, but inconsistently. The result was a patchwork of interpretations that often favored the state over the citizen. Now, with a unanimous 9-2-0 ruling, every court in the United States is officially on notice. Here's what comes next. Pending excessive force cases will have to be reevaluated under this new, broader standard. Old cases dismissed under the narrow doctrine may now be revived on appeal, and future lawsuits will rely heavily on Barnes versus Felix as binding precedent. In plain English, this ruling is reshaping federal jurisprudence across all 50 states. Attorneys representing victims of police overreach now have something they've lacked for years. A Supreme Court-approved argument that context is constitutionally required. That single shift gives new life to cases that once seemed unwinnable and new accountability to agencies that once felt untouchable. If you're a gun owner, here's a hard truth that rarely the gun owner's reality check gets said out loud. You're more likely than most Americans to interact with law enforcement. It could be something simple in a traffic stop, a range inspection, a hunting license check, even just a knock on your door. But in those first few seconds, everything can change, and how that moment is judged could decide your future. That's why this ruling matters, because it finally shifts the legal playing field. It gives citizens the power to challenge wrongful actions without being trapped by narrow legal loopholes. Attorneys the ability to argue your rights based on full fact-driven context, not just a snapshot in time. Judges the authority to demand real accountability from officers who escalate when they didn't have to. No, and this ruling doesn't make all use of force illegal, but it does something equally important. It raises the bar. It forces the system to justify that force with full context, not just fear. And for gun owners, especially those who carry concealed or open carry, this means something big. It's not just your actions that matter anymore. Now, the officer's decisions before and during the encounter matter just as much. That kind of legal balance was long overdue. The role of the Second and Fourth Amendments. Together for years, the Second and Fourth Amendments were treated like they belonged in separate courtrooms. One was about your right to carry a firearm. The other was about your protection from searches, seizures, and state force. But this Supreme Court decision just did something historic. It brought those two worlds together. Here's how they now connect. The Second Amendment protects your right to carry. The Fourth Amendment protects your right to not be searched, seized, or harmed just because you're carrying legally. Let that sink in. Your gun rights don't mean much if the state can treat your legal carry as a threat. This ruling says that's no longer acceptable. From now on, the government can't use your lawful firearm possession as an excuse for deadly force unless the full context supports it. That's more than a legal change, and that's a shield every responsible gun owner needs to know about because it's not just about one case. It's about a historic convergence of two foundational rights. And the courts finally recognized how deeply those rights depend on each other. What happens? What this means? Going forward next, a lot and fast. Legal experts are already calling Barnes versus Felix the Miranda ruling for use of force cases, a turning point that redefines how the Constitution protects you during encounters with the state. And this isn't just theory. The real-world impact is already unfolding. Here's what's coming down the road. Police departments will need to retrain officers, not just on how to react, but how their actions before a shooting will be judged in court. Officers will be held accountable for how they escalate or de-escalate long before a weapon is ever drawn. Gun rights advocates now have a sharp, Supreme Court-backed legal tool to defend armed citizens caught in gray area confrontations. And states and municipalities, they're on notice. New lawsuits, policy revisions, and intense public pressure are coming fast to force alignment with this broader constitutional interpretation. And let's not forget the loudest message of all. This was a 9-0 ruling. That's not politics. That's principle. And it may mark the start of a new era, one where police powers are finally restrained, constitutional rights are truly enforced, and everyday citizens get the respect and protection the Constitution always promised. This ruling may not be lighting up headlines, why this decision matters for all of us on cable news, but make no mistake, it should be. Because whether you're a gun owner, a self-defense advocate, or just someone who believes in a fair justice system, Barnes versus Felix changes the entire landscape. It's a firm reminder that your rights don't disappear when you're pulled over, questioned, or confronted. The Supreme Court's message couldn't be clearer. Constitutional rights require context, not convenient. If you've ever wondered whether a court would actually look at all the facts in a controversial use of force case, now there's hope. And if you've ever worried about being misunderstood while legally carrying, now there's precedent on your side. This isn't just a win for the legal world. This is a win for everyone who believes in accountability, fairness, and freedom under the law. So here's what I'd like you to do. Share this video with your community, your friends, your family, anyone who cares about their rights. Because this ruling, most people don't even know it happened, and they need to drop a comment below. Does this decision make you feel more protected, or are you still concerned about how it'll play out on the ground? And most importantly, hit that subscribe button to stay locked in with gun law updates. We cover real rulings, real cases, and real impact on your Second and Fourth Amendment rights. Until next time, stay sharp, stay legal, and always stay free. We'll see you in the next one.